Assalamualaikum and good day, Dr. Hafiz Hakimi. Today, my group, which is Group 4, will be presenting on the law relating to the offence of rape in the United Kingdom. So before I begin, allow me to introduce my group members. So myself, which is Aina Husna, Aisha Imanina, Siti Aisha, Amanda Nicole, and Q Shi Hua. So first of all, what does rape mean? Rape generally means any unlawful sexual intercourse or any other sexual penetration of the vagina, anus, or mouth of another person with or without force by a male sex organ without the person's consent. This generally means that sex crimes that do not involve any penetration with a penis specifically cannot legally be considered as rape. This will either fall under the category of assault with penetration or sexual assault. Only a man can be convicted for the offence of rape as the penetration must be committed by a biological man's sexual organ. The Sexual Offences Act 2003 is a law that governs rape in the United Kingdom, which reorders and restructures all sexual offences whose rationale and structure reflected their piecemeal development through the common law. Prior to the 2003 Act, which was before the Act was amended, only penetration of the woman's sexual organ known as a vagina was considered as rape. However, upon revision of the section, the term rape was extended to also include oral and anal penetration by a man's penis. The definition of rape can be found in Section 1 of the Sexual Offences Act 2003, whereby a person commits an offence if he intentionally penetrates the vagina, anus, or mouth of another person with his penis, and he knows that B does not consent to the penetration and does not reasonably believe that B consented to it.
So the first element to establish rape under United Kingdom law is adthesis. The first adthesis of rape is the penetration of vagina, anus, or mouth of the victim. Penetration other than penis, such as tongue, finger, objects not considered as rape. And this offence is classified under sexual assault rather than rape. Victims of rape under United Kingdom can be both male and female. Women could be a victim of rape in all three categories, while a man could be a victim of rape through mouth or anus. Even the slightest degree of penetration is sufficient to commit a person of rape. Section 72, subsection 2 of Sexual Offences Act, penetration as a continuing act from entry to withdrawal. So, based on the case of Kaitamaki 1985, a lady was having sex with a man but decided she wanted to stop and asked him to, but he didn't stop. He argued that when he penetrated her, she had consented. When she withdrew her consent, he had already penetrated. So the next point is, penetration must be made by a penis. The definition of rape makes clear that the offence can be only committed by any biological man. Section 79, subsection 3 of Sexual Offences Act 2003 states that reference to part of the body includes surgically. It does include transsexual males, any parts of the body which include surgically constructed part. Hence, trans men can be guilty of rape as they still have penis as part of their body. Next, B did not consent. Every consent involves a submission, but not every submission involves consent. Levels to consent can be divided into two, which are mere submission test and reluctant acquiescence. Mere submission is not consent, while reluctant acquiescence is accepting something without protest, is the same as consent. So how about the mens rea in rape? The first mens rea is intentional penetration. Penetration of rape must be intentional, and unless A was intoxicated to the extent he did not form such an intention, however, it will not be used as defense. In the situation where A accidentally penetrates an orifice, A will not be convicted of rape. So the next mens rea in rape is A had no reasonable belief in consent. In Section 1, subsection 2 of Sexual Offences Act, whether a belief is reasonable is to be determined having regard to all circumstances, including any steps A has taken to ascertain whether B consented or not. So, it requires proof that defendant did not reasonably believe that the complainant was consenting. So, D knows or act believing there is no consent. Also, defendant would be liable if he recognized the risk that the complainant might not be consenting and still went ahead with it. But if defendant had intercourse with a woman believing her to be not consenting, but she actually consent to it, then he will not be liable as the adthesis will not be present. So the next point is consent in rape. Section 74 of Sexual Offences Act 2003 define consent. A person consents if he agrees by choice and has the freedom and capacity to make that choice. Submission is not the same as consent, especially if it's made out of fear. In the given situation of Olok Buja 1981, two women were taken by two men to their flat instead of being taken home. One of the women was raped in a separate room. Later, one of men returned and have sex with the other woman, claiming that he believed she had consented because she didn't protest. It is important to understand that consent must be freely given and enthusiastic, and the absence of protest does not imply consent. Consent can be expressed or implied through word or conduct, but for the absence of consent, it is not necessary that be positively dissented, protested, or resisted. So can rape be happen in a legal marriage? So in the case of R against R, a decision in which the House of Lords determined that under English criminal law, it is a crime for a husband to rape his wife. The defendant in this case was charged with attempted rape under Section 1, Subsection 1 of the Sexual Offences Amendment Act 1976 and with assault occasioning actual bodily harm under Section 47 Offences Against the Person Act 1861. The court in this case upheld his conviction for attempted rape. There was no marital rape exception under English law, and this was a common law fiction that existed.
In UK, there are three types of statutory rape. Firstly, rape of a child under the age of 13. Section 5 of the Sexual Offences Act 2003 stipulates that it is an offence if a person intentionally penetrates with his penis to the vagina, anus, or mouth of a child under 13. And Section 6 states that it is an offence if a person intentionally sexually penetrates the vagina or anus of a child under 13 with a part of his body or anything else. Consent in these offences is irrelevant, as a child under 13 does not in any circumstances have the capacity to consent to any form of sexual activity. Therefore, the defence of reasonable belief does not apply if the child is under the age of 13. In the case of R vs G, a 2008 case, a 15-year-old boy engaged in sexual intercourse with a 12-year-old girl. He was charged with Section 5 of the Sexual Offences Act for raping a child under 13. Initially, the girl had claimed that the intercourse was non-consensual. However, the boy claimed that she represented herself at the age of 15 and also claimed that the intercourse was consensual. However, Section 5 imposes strict liability, making the consent of the girl not considered a defence. And there is no defence based on a reasonable belief that the girl was 13 years old or older. Ultimately, the boy pleaded guilty. His appeal was also dismissed by the House of Lords. The second type of statutory rape is provided under Section 9, whereby it is an offence if a person intentionally engaged in sexual touching of another person where the other person is under 16, where it involves penetration of the anus or vagina of the victim using any part of the offender's body or any object, or penetration of the victim's mouth with the offender's penis, penetration of the offender's anus or vagina with any part of the victim's body, or penetration of the offender's mouth with the victim's penis. In these situations, it is irrelevant whether the accused person and the victim were acquainted or strangers, as well as whether the incident was the first instance or part of a series of occurrences. However, there is a defense available if the accused person had a reasonable belief that the child was 16 years or older, except in cases where one party of a legally married couple from overseas is under 16. Therefore, if the complainant is between the ages of 13 and under 16, no offence is committed if the suspect genuinely believed that the complainant was over 16 years old. The third type is provided in Section 16, where a person can be charged with this offence if they intentionally engage in sexual touching with the victim, where the offender is in a position of trust in relation to the victim and either victim is under 18 and the offender does not reasonably believe that the victim is 18 or older, or the victim is under 13, unless sufficient evidence is presented to question whether the offender reasonably believed B's age or knew of the circumstances establishing the position of trust. The primary purpose of the abuse of trust of provision is to safeguard individuals aged 16 and 17 who are considered particularly susceptible to exploitation by those who hold positions of trust or authority in their lives. These offences focus on situations where the child appears to consent to the activity, but that consent is deemed irrelevant due to the specific relationship they have with the abuser. While a 16-year-old and a 19-year-old can engage in consensual sexual activity in the UK, since the age of consent is 16, it's crucial that the age 19-year-old does not hold a position of power, authority, or responsibility over the 16-year-old, such as being their sports coach, teacher, or caregiver. If the older individual does hold such a position, they may face charges of statutory rape under offences relating to a child under the age of 18.
The punishment of rape is stated under Section 1, Subsection 4 of Sexual Offences Act 2003 that a person guilty of rape on conviction on indictment is liable to imprisonment for life. In most serious cases, the maximum sentence for rape is a life sentence. Normally, the court will evaluate the dangerousness of the defendant and whether a life sentence is necessary. A defendant is likely to be put under a life sentence if he has committed the same act before. Basically, the principles for the assessment of dangerousness are set out at Part 10, Chapter 6 of the Sentencing Code. Generally, a defendant will be sentenced to between 4 and 19 years imprisonment to rape. The length of the sentence is subject to the facts of the case. When calculating the jail sentence, the court will take into account both the harm caused to the victim and the culpability of the defendant. By reference to the table produced by the Sentencing Council, factors that increase the court's perception of the harm caused to the victim by the rape include abduction, violence, forced entry in the victim's home, severe psychological or physical harm, pregnancy, or an STI or STD as a consequence of the offences, and additional degradation or humiliation caused to the victim. Additionally, factors affecting the culpability of the defendant include the defendant abused a position of trust. There was a significant degree of planning by the defendant, or if the defendant acted together with others to commit the offence, where the defendant used alcohol or drugs on the victim to facilitate the offence, and where there was a previous history of violence against the victim. On the other hand, punishments of statutory rape are laid out in a few sections. First and foremost, Sections 5 subsection 2 and Section 6 subsection 2 provides that if there is rape of a child under 13 and assault of a child under 13 by penetration, the person on conviction on indictment shall be liable to imprisonment for life. Next, in the case of sexual activity with a child, Section 9 subsection 2 clarifies that if there is penetration involved, the person can be charged with a maximum prison sentence of 14 years. Otherwise, the maximum sentence is 6 months, a fine, or both. Moreover, offences relating to a child under the age of 18 is stated under Section 16 subsection 5. If it is on summary conviction, the person is liable for imprisonment for a term not exceeding 6 months or a fine not exceeding the statutory maximum or both. If it is on conviction on indictment, the person is liable for imprisonment for a term not exceeding 5 years. For defense of statutory rape, the defendants must prove that the victim has misled them about her age, and it was reasonable to think that the victim was of that claimed age. For example, if a 14-year-old girl shows a fake ID that claims she is 70.
In conclusion, many of the issues with the rape legislation arise from attitudes towards women and sex, as well as false belief about the crime itself. It's also common for victims frequently reflect on what occurred to them and question whether it qualifies as rape. The law regarding rape in the United Kingdom clearly stated many types of rape, what is considered rape, as well as consent. Examined features of current legislation include those requiring proof of non-consent and criminal intent, which is the perpetrator's desire to engage in sexual activity with the victim while believing she is not consenting. Therefore, accepting the severity of what occurred is the first step towards justice and the recovery process. Victims should receive help even if it turns out that the crime goes by a different level, since it was still a violation.